Hi guys, welcome back to Just Law Legal Information sections. My name is Emmanuel Patrick. I am an LLB candidate at the University of Lay Adventist of Kigali Law School. I've elected to use my platform to discuss and share legal information surrounding several subjects including fundamental rights and freedom, criminal law, criminal and civil procedure, contract and tort liability, public international law, amongst others. Further, I will be focusing on the Liberian and the Rwandan law. Please kindly follow my page on Facebook, Instagram, Twitter, and TikTok to view my contents whenever I post. And please also like, comment, and share this video. During the last series, we discussed our introduction to law. In today's series, we are going to be talking about introduction to the law of contract. And we are going to cover the definition of contract. We will also go further to discuss the notion of a free contract, a form of a contract, the essential elements of a contract, and how contracts are enforced. So if you are ready, let's get started. What is contract? A contract is a legally binding agreement between or amongst parties. In other words, it is a promise or set of promises which can be legally enforced by the law. The agreement creates rights and obligations which may be enforced by the court. Usually, the normal method of enforcement for a contract is an action for damages for any breach of the contract. In other cases, the court may order the performance by the parties in default. I am guessing you want to know what performance by default means. This means that a court may order the parties to honor the obligations of the contract. What is the notion of a free contract? Having understood what a contract is, a notion of a free contract, under the notion of a free contract, the parties must enter into the agreement freely without any form of coercion or undue influence. In addition, the agreement must not be for illegal purposes or contrary to public policy. So we proceed to discuss the form of a contract. There are three major forms a contract can take. It includes verbal, a written, or partly verbal and written. So what are verbal contracts? Many contracting arrangements use verbal contracts. It works well if there are no dispute, because when there is a dispute while the contract is legitimate, it can be very difficult to be enforced by a court. However, verbal contracts can lead to uncertainty about each party's rights and obligations. A dispute may arise if you have nothing in writing explaining what you both agree to do. So, what are written contracts? Written contracts provide more certainty for both parties than verbal contracts. They clearly set out the details of what was agreed. Matters that can be set out in a written contract include the materials, the time frames, the payments, and the procedure to follow in the event of dispute. It is much safer to have something in writing than to rely on someone's word. A written contract will give you more certainty and minimize your business risk by making the agreement clear from the outset. So what is partly verbal and written contracts? Is that some agreements may be only partly verbal. For example, there may be supporting paperwork such as a quotation or a list of specifications that also forms part of the contract. At the very least, you should write down the main points that you agreed with the hirer to avoid relying on your memories. Keep any paperwork associated with the contract. The paperwork can be used later in discussions with the other party to try to resolve a problem. If the dispute becomes more serious, It may be used as evidence in a court. We move on to bilateral and unilateral contracts. We'll first of all begin with bilateral contracts. What are bilateral contracts? When bilateral is used, what comes to our mind? So we say bilateral contract is a contract between two parties. It is a promise made by one party in exchange for a promise by another party. Also, we can consider bilateral contract as a one-on-one contract. On the one hand, we have the offerer, a person who makes the offer, and on the other hand, we have the offeree, the person to whom the contract was made. An example of a bilateral contract is the contract of sale. For example, the buyer promises to pay the price and the seller promises to deliver the goods. So what is a unilateral contract? A unilateral contract is a promise made by one party in exchange for an action by another party. Also, we can consider unilateral contract as a one-to-all contract. An example of a unilateral contract is, for example, John promises to give anyone who will find his missing phone and return it $500. John binds himself automatically to the promise, but no one is forced to search for John's missing phone. But if Peter, for example, having seen the offer, finds the phone and returns it, he is entitled to the reward as promised by John. Essential elements of a contract. So what are the essential elements of a contract? In order to form a legally binding contract, there must be 6 essential elements. We have the first element, which is offer, the second, acceptance, the third, consideration, the fourth, intention to create legal relations, the fifth, capacity, and the sixth, absence of vitiating factors. So what is an offer? An offer is a statement or action that indicates a willingness to agree. An offer must be communicated to the person who is meant to accept it and may be made by words or conduct. What is acceptance? Acceptance is the act of agreeing to form a legally binding agreement based on an offer provided by the other party. It is an essential element of a contract, and without it, a contract will not be valid or binding. Consideration. What is consideration? In a contract, both parties must have provided consideration. That is, each side must promise to give or to do something for the other party. The fourth is the intention to create a legal relations. The parties must have intended their agreement to have legal consequences. The law does not concern itself with purely social or domestic agreement. And what is a capacity? Capacity is the capability and power under the law of a person to occupy a particular status or relationship with another person or to engage in particular undertaking or transaction. For example, the contract of marriage. Under Rwandan law, a person must be 21 years to be legally capable to engage in a contract of marriage. In the absence of vitiating factors. What do we mean by absence of vitiating factors? Vitiating factors are factors which can cripple or invalidate the contract. They are concerned with misrepresentation, mistake, duress, undue influence, and illegality. How are contracts enforced? The normal method of enforcement for a contract is an action for damages, for any breach of the contract. In other cases, the court may order performance by the parties in default as was explained initially. Also, enforcement of contracts may either allow the contract to resort to being a void contract or a voidable contract. So what is a void contract? A void contract means that a contract does not constitute or does not exist at all. The law cannot enforce any legal obligation to other party, especially the disappointed party, because they are not entitled to any protective laws as far as the contracts are concerned. An agreement to carry out an illegal act is an example of a void contract or void agreement. For example, a contract between drug dealers and buyers is a void contract simply because the terms of the contract are illegal. In such a case, neither party can go to court to enforce the contract. Thanks so much for watching. Hope to see you another time. Please comment in the comment section and let me know what you would like me to discuss next. Thanks and have a good day.